So, a perfect time to bring in Professor of Constitutional Law at Princeton University and Director of the Princeton University Program in Law and Public Policy, Deborah Pearlstein. And Deborah, you have a guest essay for the New York Times entitled, "The Law is Not Fully Trump's Yet." And you write in part this: Mr. Trump is hardly the first president to claim broad executive power. The difference this time is not only the enormity of his claims, a level of authoritarian aspiration that far exceeds any other in the modern American age, it's that the administration hardly even bothers to try to craft legal justifications for its actions. Presidents have enormous power under the law. Part of what Mr. Trump is doing is just invoking the breadth of that authority. For those worried about the fate of our democracy, it would be foolish to rely on the rule of law alone. But it would also be wrong to simply write it off as a meaningless check on presidential authority. That kind of pessimism becomes our self-fulfilling fate. The new president may be aiming for authoritarian control, but the law is not fully his yet.
Deborah, thanks so much for being with us. There are several things that you wrote in here that really jumped out at me. First of all, just a quick summary. 63 of 63 federal courts rejected in 2020 Donald Trump's attempts to overturn the election. Throughout the first term, Federalist Society judges time and again on all levels pushed back against him. And I just wrote down really briefly the 11th Circuit overturned the district court judge Cannon to release a January 6th report. The Supreme Court rejected his immunity claim, made him go to his sentencing hearing, at least by video, to be sentenced right before the inauguration. And of course, the D.C. Circuit has put a freeze on his spending freeze, an injunction on the spending freeze. But Deborah, the line that you wrote that jumped out at me was that part of the belief that our third branch is going to kowtow to Donald Trump is based on a misunderstanding of the immunity case. And Mika will tell you, I took the entire case out about a month ago and reread it. And you are right. It was oversimplified. It wasn't the Supreme Court kowtowing. There are three silos. I also heartened by Amy Coney Barrett's concurrence. I see some evidence that the courts just may do their job over the next 4 years. Talk about why you believe that as well.
Well, first, thanks for having me. But so on the immunity decision, right, I think the immunity decision was a terrible decision and wrong as a matter of constitutional law. But it was really limited to the question of a former president's individual criminal liability under the law. Most of the way we enforce constitutional law in this country is not by holding people criminally liable when the Constitution is violated, but by telling government officials they have to stop doing what they're doing. And already what we're seeing in the more than 24 cases that have already been filed against various actions that the new administration has taken, the first three courts off the bat at the district court level have said, one with respect to the birthright citizenship executive order, and two with respect to these attempts to engage in across-the-board spending freezes in the government. You have to stop that. You can't do that. The courts call them temporary restraining orders. But that's what we're seeing so far at the district court level. Those things have nothing to do with criminal liability for anybody, but they're enormously important in keeping the Constitution on the right track. That is to say, they're enormously important in preserving the separation of power system we have. Congress's power of the purse is its and its alone under the Constitution. And if it loses that, if it cedes that to the president, then we have a government of whatever the president says goes. That's not a constitutional system. That's an authoritarian system. And that's something that I think not even this Supreme Court is prepared to do. I certainly don't think that the Trump versus United States decision speaks to that issue one way or another.
Well, it doesn't. And also, though, again, I think it's a terrible decision. I do think that it was presented in such a way that people thought, oh, the Supreme Court. Well, just like you said, the Supreme Court's going to bow down on every single issue. I mean, talk about specifically these funding issues, whether you're talking about U.S. aid, whether you're talking about this general freeze, which the Trump administration is saying, well, we're doing it temporarily. We're going to take a look at what best practices are, see if we can save some money. But talk about the court challenges that will come forward there and what the D.C. Circuit, what the Supreme Court will most likely do.
So first, I should say a lot of these cases aren't being filed in the first instance in Washington, D.C. One of the injunctions comes out of a federal district court that sits in Rhode Island. One of them does come out of a federal court that sits in D.C. The first birthright citizenship case to get to the courts is one out of Washington state. So there are federal courts across the country. All of these ultimately funnel into the U.S. Supreme Court. But the spending issue is really quite striking. And like the birthright citizenship question, one of the unusually clear parts of the Constitution. So what we'll see in these challenges, whether it's USAID or some of these across-the-board spending freezes that still seem to be, at least to some degree, in effect in some agencies, and the courts are sorting that out now, what we'll see are at least two different kinds of challenges. One is just a simple, straightforward constitutional challenge that the spending power is Congress's under Article 1. But more directly, there's also a separate federal statute called the Impoundment Control Act that was passed after Richard Nixon's presidency, when Nixon attempted very similar techniques to try to pause, or what he called pause, federal spending, but what were really cutoffs. The same thing that Trump tried in the last administration when he tried to withhold money that Congress had appropriated for aid to Ukraine. And the issue is, Congress has said very clearly, we mean it when we say under the Constitution, the power is ours. There are a few very limited circumstances when presidents are permitted to pause spending. But this administration isn't even attempting to invoke that law or those circumstances. Mm-hmm. They simply don't apply here. And as we're seeing, I think, very quickly from these initial courts to hear these cases, they're not. They think, and they have said, that the plaintiffs in these cases, some of them are states of the United States, some of them are NGOs who are affected by the spending cutoffs. They've said, look, the plaintiffs here have an enormously high chance of prevailing on the merits when we get to the question of constitutionality, when we get to the question of legality. So while we sort out all the details of exactly what we're doing, we're putting in place a federal court order that tells you to stop. And we saw over the weekend the Department of Justice circulate a memorandum inside the administration saying this federal court order is in place, and while it is in place, you must comply. And we are interpreting these orders very broadly, not just to extend to programs that are identified by the plaintiffs in those particular cases, but to extend to spending pauses, whether they were put in place by a memorandum or an executive order across the system. So that's where things stand now. As it stands, the administration is precluded by a federal court order from extending these spending pauses. Again, over time, we'll see how the courts address this. But at least on these very broad, the president has the power to wave a wand and take away Congress's power of the purse. I'm not seeing any indication, and I'm not confident that the administration will prevail.
So, Professor, you point out in the piece something I'm sure most people aren't aware of, which is that in the first Trump administration, more than 200 federal judges were appointed, and he had the 3 justices on the Supreme Court on his watch. But his administration had a kind of historically bad track record in front of the Supreme Court and in a lot of these cases. Do you feel that something is different this time around than it was during Donald Trump's first time? Obviously, we've seen the impact of the kind of people he's put around himself who are loyal and willing to execute whatever he says. But in terms of the judiciary system, is it different this time than it was the first go-round?
So there are a couple of differences, one of which may make it more likely that Trump prevails, but the others, I think, make it much less likely. The one difference, of course, is that during part of Trump's first administration, Ruth Bader Ginsburg was still on the court, and the Republican majority on the court was roughly, as the votes tended to go, or as the votes in the closely decided cases went, 5-4, not 6-3. And that makes a difference, right? The additional justice makes a difference. That said, there are now more Biden appointees on the federal bench than there were during Trump's first term. And I think maybe most important here, at least so far as we're seeing in these initial round of executive orders and memoranda, they don't have the legal aid team on their side this time. They're not really trying to make legal arguments. They're not really trying to set these cases up in a way that the courts, even the Supreme Court, are likely to embrace them. They're making mistakes. They're making, in constitutional terms, silly mistakes. And those make their actions much more vulnerable to legal challenge, even in front of this court. If I could make just one last point, right, we're seeing this court not change, right? It's an extremely conservative court. There's no question about that. But even over the course of the last term, we've seen some of the justices begin to shift their views, not on questions of abortion and guns and so forth, but on questions of holding the line against these fundamental issues of power under the Constitution. And that's really what this administration is pushing on. So far, not the major social issues, but things that are bedrock principles that keep our country one that remains a constitutional democracy as opposed to an authoritarian regime.